Dear reader, reading of article. Relevant provision for this article is Section 29 of the CGST Act, which provides for cancellation or suspension of registration. Section 29, subsection 1, the proper officer may, either on his own motion or on an application filed by the registered person or by his legal heir, in case of a death of such person, cancel the registration in such manner and within such period as may be prescribed, having regard to the circumstances where, Clause A, the business has been discontinued, transferred fully for any reason, including death of the proprietor, amalgamated with other legal entity, demerged or otherwise disposed of, or there is any change in the constitution of business, or the taxable person is no longer liable to be registered under Section 22 or Section 24, or intends to opt out of the registration voluntarily made under subsection 3 of Section 25, provided that during pendency of the proceedings relating to cancellation of registration filed by the registered person, the registration may be suspended for such period and in such manner as may be prescribed. Subsection 2. The proper officer may cancel the registration of a person from such date, including any retrospective date, as he may deem fit, where a registered person has contravened such provision of the Act or the rule made thereunder as may be prescribed, or a person paying tax under Section 10 has not furnished the return for a financial year beyond 3 months from the due date of furnishing the said return, or any registered person other than a person specified in Clause B has not furnished return for such continuous tax period as may be prescribed, or any person who has voluntarily taken registration under subsection 3 of section 25 has not commenced business within 6 months from the date of registration, or a registration has been obtained by means of fraud, willful misstatement or suppression of fact, provided that the proper officer shall not cancel the registration without giving the person an opportunity of being heard, provided further that during pendency of the proceeding relating to cancellation of registration, the proper officer may suspend the registration for such period and in such manner as may be prescribed. Subsection 3. The cancellation of registration under this section shall not affect the liability of the person to pay tax and other dues under this Act, or to discharge any obligation under this Act, or the rules made thereunder, for any period prior to the date of cancellation, whether or not such tax and other dues are determined before or after the date of cancellation. Subsection 4. The cancellation of registration under the State Goods and Service Tax Act or the Union Territory Goods and Service Tax Act, as the case may be, shall be deemed to be cancellation of registration under this Act. Subsection 5. Every registered person whose registration is cancelled shall pay an amount by of debit in electronic credit ledger or electronic cash ledger equivalent to the credit of input tax in respect of input held in stock and inputs contained in semi-finished or finished goods held in stock or capital goods or plant and machinery on the day immediately preceding the date of such cancellation, or the output tax payable on such goods, whichever is higher, calculated in such manner as may be prescribed, provided that in case of capital goods or plant and machinery, the taxable person shall pay an amount equal to the input tax credit taken on the said capital goods or plant and machinery, reduced by such percentage points as may be prescribed, or the tax on the transaction value of such capital goods or plant and machinery under section 15, whichever is higher. Subsection 6. The amount payable under subsection 5 shall be calculated in such manner as may be prescribed. The article is titled Cancellation of GST Registration without determining the amount payable by the assessee is cryptic, invalid and not sustainable. It is written by C.A. Bimal Jain sir. The Honorable Gujarat High Court in Mesar Devi Products versus State of Gujarat R Special Civil Application number 2288 of 2022 dated February 15, 2023 has set aside the show cause notice issued to the assessee and the consequential order for cancellation of GST registration on the ground that they were passed without recording any reasons and without determining the tax demand, and thus are cryptic in nature. Held that cancellation of GST registration without any determination of the amount payable by the assessee is not valid and sustainable. Fact of the case is Messrs. Devi Products is the sole proprietor engaged in the business of trading of brass articles. The petitioner has filed its return till June 2020. However, due to prevalent circumstances during COVID-19 pandemic, the petitioner had no business subsequent to June 2020, and due to the financial hardship suffered, the petitioner was of bona fide belief that there was no requirement to file GST returns. Subsequently, a show cause notice dated March 15, 2021 was issued by the respondent department under Rule 22 Subrule 1 of the CGST Rules 2017, read with Section 29 of the CGST Act 2017, whereby the petitioner was informed that its GST registration was liable to be cancelled for not filing return for a continuous period of 6 months. The GST registration of the petitioner was also suspended on 15th of March 2021 under Rule 21A of the CGST rules without recording any reasons. Thereafter, the GST registration of the petitioner was cancelled by the respondent with effect from 1st of July 2017. Wide order dated March 24, 2021, without recording any particulars or the reason or the grounds for cancellation and without determining the tax demand. Being agreed, this petition has been filed. The issue in this case was whether impugned SCN and impugned order without recording the ground for cancellation of GST registration and without determining the tax demand are sustainable. Held that the Honorable Gujarat High Court in R Special Civil Appeal number 2288 of 2023 held as under relied on the judgment of the Honorable Supreme Court in Krani Associates versus Masood Ahmed 2010-9 SCC 496, wherein it was held that a recording of reasons is meant to serve the vital principle that justice must not only be done but it must also appear to be done, and it would also operate as valid restraint on any possible arbitrary exercise of judicial and quasi-judicial or even administrative power. Further, it reassures that discretion has been exercised by the decision maker on relevant grounds and by disregarding extraneous consideration and facilitates the process of judicial review by the superior court. Noted that the respondent ought to have at least incorporated the specific detail of the contents of the impugned SCN, whether in which any prudent person can respond to, as otherwise it would fail to respond to such SCN, which is bereft of details, thereby making the mechanism of issuing SCN only a formality. Stated that the very nature of impugned SCN and the impugned order was cryptic and unsustainable under law, as well cancelling the GST registration, the respondent had not even determined the amount payable pursuant to such cancellation. Held that the cancellation of GST registration without any determination of the amount payable by the petitioner is hardly sustainable, and such action cannot be ratified in any manner, quash the impugned SCN and impugned order. Permitted the respondent to issue fresh SCN with the particulars, reasons, incorporating the details, and directed to provide reasonable opportunity of hearing to the petitioner. Read this article by yourself. The article is titled Cancellation of GST Registration without determining the amount payable by the assessee is cryptic, invalid, and not sustainable, written by CA Vimal Jain sir. This article is available under article section. Thank you.